Good day, Internet. Chavez and Valco here. I am Senior Associate Benjamin Hamilton, and with me, as always, is Associate Attorney Andrew Craven. We are the key to your immigration solutions. And you know, when you see our smiling faces, we are talking about all things employment based immigration. Today, we are going to be talking about the Form I-140 after an approved labor certification. So, we are talking about filing for residency through your employer. Now, this is a multi-step process that where first you have to get a labor certification from the Department of Labor. We actually have 3 videos covering that process. And now we're going to be talking about the I-140, which is filed with USCIS. Now, the I-140 can be filed in other contexts: multinational managers, extraordinary ability, national interest waivers. We actually have separate videos on each of those categories. Today, we're going to be talking about filing the I-140 exclusively in the context of someone with an approved labor certification in the EB2, employment-based second, or employment-based third categories. All right, so a lot of lead in there. Andrew, my labor certification was approved by the Department of Labor. What is my time frame for filing the I-140?
So the I-140 has to be filed during the validity period of that certified ETA Form 9089. So that's going to be 6 months, and you can also find it at the bottom of the PERM. It's going to list out when it starts and when that validity period ends.
So it is important that once you get your PERM labor certification, you do file that I-140 within that time frame, or you've all is for naught. You've lost kind of everything. Who actually files the Form I-140 in our specific context?
This specific context is actually going to be the employer that's filing the I-140. They are essentially petitioning for that for national.
So there are other contexts in which you can self-petition, but again, if you're talking about someone with an approved labor certification, right, there is no way to self-petition. So we're talking exclusively about people with approved labor certification. So it is the employer filing the I-140. What is the filing fee for the I-140?
It's $700.
I mean, it's not too bad. And what is the current processing time for an I-140?
So the regular processing time does vary, but right now it's about 8 months, sometimes a little bit more.
Yeah, and most go to I-140s go to one of two processing centers. It's either the USCIS Texas Service Center or the Nebraska Service Center. Can the I-140 be premium processed in this context?
Yes, so in the EB2 and EB3 categories, premium processing is available currently for 2,500. And just looping back to that last question, everyone online can always Google USCIS processing times, look at the form, and then which service center your form would be going to, and you can see those full processing times.
Exactly. You also got to kind of look, they do break it down by category. So you'll look down and you'll see EB1, outstanding or extraordinary ability, EB2. So you can kind of look at what their processing times are. So you're looking at um, 8+ months versus 15 days if you pay that additional $2,500. Again, all of this is going through now USCIS, right? All of our steps up until now with the Department of Labor, and now we're going to USCIS. So we're actually going to look a little bit at the Form I-140 itself. Um, talk about that a little bit. It's relatively straightforward, but I think there's a couple of things here we can point out. So first and foremost, when you're looking at the Form I-140, pretty much everything that's in this form needs to match with what's on the PERM labor certification. So you can't just decide, oh, I'm going to change the job code or I'm going to change the salary or, you can't do that, right? It should match up. So obviously the first page, right, um, you're putting the employer's name, address, usually like the headquarters address, their FEIN. Now, Andrew, are contexts in which the employer's name will sometimes change?
Yeah, I mean, you can have just a rebranding. You could have the company be purchased. We'll get into successor and interest conversation another time. Uh, those are kind of the main ones.
Yeah, the main ones are either like a purchase or an acquisition or a merger, right? Where it, is now has a different name. And again, that doesn't necessarily mean you have to start over if the surviving entity qualifies as a successor in interest. So that is the one context, right? Successor in interest context where the name on the I-140 may be different than what's on the perm, but it's okay. And again, you have to document that, right? So if your company, let's say, was bought wholesale by this other company, right? So now companies B's names appearing on the I-140, you're going to want to include evidence of that acquisition when you file your I-140. Here's my question: when we're filing the perm with the Department of Labor, are we at any point during that process, are we actually stating whether or not this is an EB2 or an EB3?
I mean, not overtly. You don't just sit here and state it's an EB1, it's an EB2. You're really just putting together the requirements in such a way that they will match up with either the EB1 or EB2. And ultimately, here is where you're going to declare which one you're applying for.
Exactly. It's here in part two where we select what type of application this is. So we see extra, actually, go back up to the first page. Where we're going to see here where you can select extraordinary ability, outstanding professor, multinational manager, and then we see 1D right through, 1G, where you're determining whether or not it's an EB2 or an EB3, right? So 1D would be an EB2, a member of the profession is holding an advanced degree, and 1C, F, and G would be an EB3. But actually, up until now, we've never, stated whether this is an EB2 or EB3. Now, looking at the requirements, we know which we could actually select, but it's not until you get to the I-140 stage where you actually choose if it's an EB2 or an EB3. And Andrew, why would we maybe, let's say the position qualifies for an EB2, but we actually select EB3?
I mean, generally, we would do that in situations where on the current visa bulletin, a person might be current or about to become current in EB3, whereas EB2 is still backlogged or in some way behind it. We also will do upgrades or downgrades at a later date if the person qualifies for an EB2 and we need to shuffle them between those visa categories because they might be current in one and not the other.
So for most nationalities, whether we select EB2 or EB3 is really just based on the position, which one does it support. But at the end of the day, there's really no difference between the two in terms of when you can apply for residency. EB2 or EB3 is the same. We just select the one that corresponds to the position. So when you're from India or China, that we have to take into consideration processing times and which line is ahead of the other. Because, again, if the position qualifies for EB2, you can always select a lower, right, EB3, right? Obviously, if the position only qualifies for EB3, you're locked into EB3. You can't just select EB2 if it doesn't require an advanced degree or its equivalent. Um, so there is a little bit of decision making there when we have clients that are from India or China as to which one we select. For everyone else, you just go with what makes the most sense. You don't really worry too much about it, but just always make sure you check the right box though, right? Because you don't want to, it's an EB3, you accidentally check EB2 because they may deny it, right? For that simple error. And then of course, if you didn't file premium processing, by the time you get the decision, the labor certification's already expired and now you're in serious trouble. So go to the next page. Um, we'll see that most of the information here is fairly straightforward. Most of it relates to the actual beneficiary, right? The employee, what is their name? Where are they from? If they're in the US, what is their current status? There's an important box down there in the right corner where it's about processing information. Why does part 4 there, why does that make a big difference in terms of which box we select?
Because ultimately that's going to determine uh, your process for the I-485, or if you're going to consular process for your green card. So the questions that we're going to get into there are, where is the beneficiary? Is this someone who's still outside of the country? They haven't gotten an H-1B or anything like that, and they will be going through the consulate. Are they already in the country and needing to adjust status? And basically just how are they going to process after this is approved? Where are they getting their green card?
Yeah, that's an important box, right? To know which to check correctly, because let's say they are outside of the US and you accidentally select the box 2A there that says alien is in the United States. Well, you can't, and it gets approved as such. Well, it's essentially kind of worthless to that foreign national who's outside the US, because it will never get to them. You actually have to file another form, pay another fee to get USCIS to move it to the National Visa Center, who will then process the person for residency, but through a consulate or embassy. Now, in most cases, we're doing this for people that are here in the US, they're in H-1B status, they're in TN status, they're working for the employer. We just select 1A, alien will apply for, 2A, alien is in the United States and will apply for adjustment of status. Not a problem, right? But again, you can do this for somebody who's actually not currently in the US, not even currently working for the company. And again, if they're going to be doing it through the embassy, it's important that you select the right box, which is the 1A box. Because again, if it needs to be 1A and you accidentally select 2A, you're going to have to file another form, pay another fee, and wait another 8 months to get them to move it, right? It's a big headache. Whereas if you select 1A right off the bat, the second it's approved, it automatically gets moved to the National Visa Center for processing abroad, and you don't have to file anything additional. So we'll go down to the next page here, which is just a little bit more information from the beneficiary. They want to know, what is their foreign address. Again, if they're in the US, then you just put their last address abroad if they're in the US. Obviously, we select whether or not we're concurrently filing for adjustment. Again, if you're Indian or Chinese, you can't really do this, right, because of the backlogs. But let's say you were from England, you could actually file your I-1. The employer could file the I-140, and the employee could file their application for residency at the same time. It's called concurrent filing. So those are the boxes you're checking up there, just to say, hey, am I filing this I-140 with the adjustment or not? And then, part 5, we start getting into some of the employer information, right? Pretty straightforward. You check whether you're, in this case, right, it's always going to be 1A, the employer, right? Because if it's a labor certification, you always have to have a sponsor. Type of business, date established, number of employees, gross annual income, net annual income, right? We have to put the labor certification number, which comes off of a PERM. Go down to the next page. And this is pretty much just all information straight from the PERM, right? There should really be no deviation here at all. What is on the PERM in terms of when was it filed? What's the expiration date on it? What is the job title, SOC code, job description? Under the job description, we usually just write C approved PERM. Like, we don't try to write it out. It's really long. Obviously, since it's a full-time position, permanent. You just want to make sure you get these boxes right, because if you accidentally check one wrong, you'll get an RFE and then probably have to submit a new form with the RFE. Say, oops, sorry, we checked the box wrong. Here's the box correctly checked. Obviously, the wages. We set up at the front. The employer usually puts their headquarters location, but then here you put what's the actual worksite location. Again, that worksite location should match what's on the PERM. You cannot deviate at this point. If you do deviate, you'll probably be denied. And if you need to deviate, then you might have to start over. And then you see here, we add in family members. We include all family members, even if they're U.S. citizens. So you have a child that was born here. We just put country of birth, U.S., and then it says, are they applying with you? Then, no, right? And then go down to the next page here. More family members, next page. And then it's just a bunch of signatory stuff, right? So at the end of the day, the Form I-140, I would say, is relatively straightforward. It's mostly about making sure you fill it out correctly. You're checking all of the right boxes that need to be checked. And then second, making sure it matches what is on the approved labor certification. I mean, I know when I get one for review from a paralegal, I grab the labor certification and I'm there double checking that everything lines up. That's the most important thing. So let's move on to the document requirements. This is where it gets a little more nitty gritty. This is where people run into issues with their I-140. So Andrew, what are the main document requirements for when I file my I-140?
So there are two key things that need to be documented here, right? First is going to be the employer's ability to pay the offered wage. Basically, they have enough money to actually pay this guy what they're supposed to when he gets his green card. And then two, the foreign national meets the education, experience, and any other requirements that are listed in that labor certification.
So we're in a second here, we're going to get into number one because that is sort of the real nitty gritty of I-140s and where people get the most challenges. But in regards to number two, from the foreign national, usually what are we submitting?
Degrees, transcripts, academic evaluation, employment verification letter. Those are letters just saying, hey, this guy worked for us from X date to Y date, and they did these duties. And any other licenses or certifications that were required in the PERM. So if you need, uh, I don't know, law license, dentist license, medical license, you got to include that too.
And again, this is about what the perm requires. So think about if you're an officer and I get this case and I look at this perm and the perm says, oh, they need a bachelor's degree in computer science and 3 years of experience in app development. And I don't know, they have to have an AWS certification. Well, I better see that they have a degree in computer science, 3 years of experience in application development, and a certificate AWS. If you don't, you're going to get a request for evidence, right? They're going to challenge you on that. Now, obviously, we need academic evaluations when the person has a foreign degree to prove that is equivalent to a US degree. But again, the main thing here is again, if it requires a bachelor's in computer science and I have a bachelor's in computer science, but I also have an MBA, it's like, well, the MBA is not really relevant. It's the bachelor's in computer science that is relevant, but sometimes they have a bachelor's in some engineering and then their master's is in computer science, right? So it's the master's that's really relevant. Um, so again, the degrees, the transcripts, academic evaluations, if they have a foreign degree, a big one is those employment verification letters, right? Andrew, we see, that's a common thing to get challenged if they're not correct. So, what are some of the things that we tend to see there?
Uh, One of the common ones is just that the verification letters say don't state whether the job was permanent or temporary, full time, not full time, and even more importantly, that the duties performed in that job or the skills and tasks performed in that job do not match the requirements in the perm. And just kind of going back to what we were talking about, this is why planning is so important from when the prevailing wage determination is filed a couple of videos back. We have to have everything line up. So you say this requires a bachelor in 5 years experience. Well, you're going to attest to that into the perm. And then ultimately, this is where we have to prove it up. So that language has to match all the way through.
Yeah. So, I mean, a common example is someone like the perm is sometimes you get these perms that are hyper specific. And we kind of tend not to like those because they create issues. But anyway, let's say you have one that's hyper specific and it says requires a bachelor's degree in computer science plus 3 years in application development, including, and then they list out a bunch of programming languages, right? Well, then the guy gets his employment verification letter from his employer showing that he has 3 years of experience in application development, but it doesn't list out the programming languages. I'm telling you, you're going to get a request for evidence because they're going to say, we don't see anything here that says that you have 3 years of experience in these programming languages, right? So that's why up front, when you're crafting the job description, you're working with the employer and the employee to ensure that they have all that experience and can get letters to back it up. So you need to be when you're reading through the requirements of the perm, you need to be able to read through those employment verification letters and see everything you need in there. Um, Another common issue, obviously, is well, where am I getting the employment verification letter from? Right? Who do they want it from? Well, they want it from the company on company letterhead, signed by a representative of the company. But Andrew, what's one of the problems we run into?
Oh, we'll have people that come. I mean, first off, company could close down. not able to get the letter, people will show up with affidavits from coworkers and colleagues, or the letter just won't be on letterhead. And ultimately, these things just don't have enough backing to do it. The other one, and maybe this is what you were getting at, is employers will sit there and say, we're just not going to do that. This is the only information that we provide. They were a software developer from March 2020 to March 2025. And we're not going to give you any more detail.
So a letter from a coworker or supervisor is considered secondary evidence. There has to be primary evidence in order to consider secondary evidence. So if we get a letter from the employer and it just says he was a software developer from this date to this date, and that is it. It doesn't talk about his job duties. It doesn't talk about any of the skills. And they say, and this is all we're going to give you. In that context, we can then combine that employer letter on employer letterhead signed by the employer with the colleague or supervisor letter that does go into more detail, right? But you can't just present the colleague or supervisor leader a letter by itself, unless it's on company letterhead and all that type of stuff, right? So there is that between what's primary and secondary evidence. And again, if the company went out of business, you can provide a letter from a former supervisor as long as you also present evidence that the company went out of business. So that's kind of your primary evidence. It went out of business, and then your secondary evidence is the letter. So first and foremost, you just want to get the letter directly from the employer on their letterhead, signed by them. That covers everything. And if you can't get that, you have to get the light letter from the employer and then combine that with the more detailed letter from preferably like from a supervisor, someone who supervised you when you're at that job. So, common issue where we just see stuff that doesn't work and we're having to push back on the employee, right, is on those employment verification letters. Don't ever assume USCIS is going to understand or see something there, right? Again, if programming languages are listed out in the PERM, they better be listed out in the employment verification letter, because they are that specific about stuff. Do we need to document to USCIS all of our recruitment steps, like include copies of the ads and all that type of stuff?
No. So at this stage, you're not including any of that if you've already finished out the perm.
Now we're going to jump into the fun part, which is ability to pay. This is the bane of all I-140s. This is probably the most common RFE, the most common challenge, the thing that gives the most headaches to employers. Again, the sort of overarching thing here is proving that the employer has the ability to pay whatever the wage is on the labor certification. So, what is the time frame that USCIS is looking at?
All the years from the time the priority date is established, which is when the perm filing date was done, and it continues until the beneficiary obtains his lawful permanent residence.
Well, hypothetically, but you could have. It takes let's say 7 months to get the perm approved, right? So no, it's already 7 months ago. And let's say it takes you another 3 months to actually file the I-140. So now you're looking at 9 months back, but then this takes them another 8 months to adjudicate it. So they could potentially send a request for evidence to cover that period during which it was pending. So there's this like window. I'm going to throw a random question out to you. If they want to, do they have the discretion to take a even wider view than that?
Yeah, they do have discretion to generally look at, I mean, the totality of the circumstances.
Exactly. Yeah. So in general, it's from the priority date all the way up until approval. Um, but if they want to, they can look beyond that. What are there any documents that are absolutely mandatory?
Yes, so the regulations require the submission of an annual report, federal tax return, or audited financial statement.
The one of those three pretty much has to be included with every I-140. No questions asked. You can't say, "Hey, this prevailing wage is 60K. I'm paying this guy 150, right? So, right, I'm paying him way over." Nope, doesn't matter. They interpret this as one of those three has to be included, no matter what. Are there any exceptions though to those three?
So yes, if the U.S. employer employs more than 100 workers, the service can actually accept a statement from the financial officer of the organization. But it does have to be a company of more than 100 workers.
Yeah, so usually we get a letter that we draft up for the CFO that just says, "Hey, I'm the CFO. We have X amount of employees. We earned, our gross, it was Y. Our net was, it's like two paragraphs. Like it's not super detailed, and then they sign it. That's acceptable. Uh, can USCIS, those are considered primary documents. Just like we talked about employment verification letters, the letter from the employer is the primary evidence, and there's secondary evidence. So in this case, the primary evidence are those three things, or maybe the letter if the company's big enough. So four things. Will USCIS consider secondary evidence, like such as bank statements?
So USCIS has discretion to consider anything, but in general, they're not going to consider other evidence in lieu of the required documentation. Those 3/4 primary forms of evidence. That is unless the employer can demonstrate why none of the above are available. So, like uh, bank statements could be considered primary evidence if there's a good enough reason for it.
Let's just say if you're in that position where you're trying to make that argument, things are not going to go well for you. Those are real. You're going to get a request for evidence, and those are really difficult cases. They tend to see stuff like bank statements on as supplemental evidence, like, oh, here's my tax return, but there's something weird there. Let me explain that through this supplemental evidence, right? Again, if you're trying to like go around this type of stuff, man, you are probably setting yourself up for failure. Um, okay, so what factors do they look at when considering when they're looking at ability to pay?
So they're actually looking at three factors in kind of a specific order. And so that first one is going to be whether the employer currently pays a wage equal to or greater than the proffered wage. So say the person's in an H-1B, they're already here and they're supposed to have a salary of 100,000. You can show they're already getting paid 100,000 or 102,000, then you're pretty much set.
And then how do we document that?
So W-2s, pay stubs, things of that nature are generally the go-to.
The idea is, hey, here's my tax return, let's say, and oh, by the way, I'm already paying him that. Here's his W-2 from the last year and his current pay stubs. And that's usually easy peasy, like really no questions asked at that point. It's pretty straightforward. Um, but you do have a lot of cases in which maybe the guy's not working for you yet, or he's working for you abroad, like for like a separate company, like an affiliated company, or like let's say the prevailing wage is 100,000, you're currently paying him 90. Do I have to when we get into this analysis, do I have to prove the whole 100, or do I just have to prove the difference between what I'm actually paying him with the prevailing wage?
In that case, you're proving the difference. So you can say, look, I already pay him 90,000. I just have to show that when I get once he gets the green card, I'll have the other 10,000 to start paying him.
Okay, so this other 10,000, what's our second factor we look at to prove that if the wages don't get us there?
So the second factor is whether the employer's net income is equal or greater than the proffered wage. So look, I currently don't have this guy. He's still abroad, but I'm going to pay him 100,000 and I made at least 100,000 on top of everything else this last year. Or better yet, we net $1 million every year and we're only going to pay this guy 100,000.
Exactly. But again, the key here though is that it's net income. So like if you're looking at a tax return, it's not that top number, which is gross. You're going down to like, well, if it's like a form 1120, that's taxable income, which I think is like a line 30. Well, if it's like an 1120s, it's ordinary business income, which is I think line 21. And again, what do companies want to do? Well, they want to throw every trick at the book, every loophole, every break to reduce their tax liability to the smallest. They want that taxable income number to be as small as it can be, negative if possible. That doesn't mean necessarily that the company's losing money, right? It could be that they have a massive amount of depreciation on an asset or something, or they um, had a bunch of recent expenses on some like R&D. Um, but unfortunately, trying to reduce your tax liability could actually hurt you in an I-140 case, because if, let's say, I'm paying the guy I'm paying the guy 80, prevailing wage is 100, I need to come up with an extra 20. My gross is, I don't know, 10 million, but then I go down net negative 10,000. Well, not going to work. I cannot use my net income to cover that 20K that I need to cover. Now, if I go down and my net income is 50K, great, right? It's enough to cover the difference. Um, can an employer, for example, one of the ones I mentioned, can an employer try to, let's say, discount or add back depreciation?
No. So the service takes the view that depreciation represents the actual cost of doing business. Whether or not that's
They're
true, probably not, but
they're
that's the
not
view
going to
they
like,
take.
you did a lot of funny accounting to get this number. They're not going to allow you to do funny accounting to undo that number in 99.9% of the cases, right? There's just like, no, whatever that number is, you're stuck with it. So let's say that number is a negative. Let's say that number is not enough or it's a negative. What's the third thing that they'll look at then?
So the third factor is whether the employer's current net assets are equal or greater to the proffered wage. So maybe you didn't net that amount, maybe you don't pay him that amount, but we currently have enough funds to pay that wage when the time comes.
And so what are they actually looking at to calculate that?
So in that case, they're looking at the difference between current assets and current liabilities, long-term assets and liabilities, which will not be due or owed within 1 year, such as like plant equipment, may not be relied upon to establish the ability to pay the offered wage.
Yeah, it's really just these are easiest to kind of see on a financial statement, right? Because it's clear, it's a little bit more clear than like a tax return. But they're only looking at net assets versus net liability. So they're literally just taking, what are my net assets? Oh, $500,000. What are my net liabilities? Oh, $700,000. I subtract one from the other. Oops, that's a negative number. That's a negative 200,000, right? So they're going to first look at, what are you paying him? And if it's at or above, great, done. If it's less, we look at your net income. And if your net income's not enough, then we go to your net assets. And then if your net assets are not enough, ooh, you're in a bad position. But it's not an impossible position. So if we look at your, um, oh, actually, I had another question I need to ask first, though. What happens if an employer files multiple I-140s for different employees around the same time?
Then the employer has to demonstrate the ability to pay all of them or identify which petitions are in fact supported by the employer's ability to pay.
So USCIS isn't stupid. So if I have, let's say, five guys and they're all underpaid by $20,000, so collectively that's $100,000. I can't say, aha, I have a net income of 20K and then use that for five guys. They're not that stupid, right? If they pick up on it, they're going to be like, whoa, 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 there's five guys here. Your net income either has to be 100K to cover all five, or if it's only 20K, you need to pick which one of the five you really like and you want to keep, and the other four are going to get denied. Which, again, why would you put all the cost and time into this if you didn't know you were going to get through it on the other side? Now, if we go through all of this and we're still short, it's not a lost cause. There, right? So one of the a case that people cite to a lot is a case called Matter of Sonegawa, and then from that there's spawned a bunch of other cases and different things. But let's say, I don't know, the employers maybe just had a bad year or two. What do we do in that case?
In that case, you're going to try to demonstrate that it was just a bad year by showing your general financial history. So, say you're a restaurant that got hit by COVID. Well, you would want to show that prior to 2020, you were doing way better. That it was a 2020 thing, and then until whenever your area loosened up restrictions and show, and now we're doing good again.
Well, in light of this case, matter Sonegawa, the USCIS issued, some guidance, and they basically say that they're going to consider three things. And what are those three things?
So, why the year in question was uncharacteristically unprofitable. The second would be that the petitioning entity had experienced a succession of profitable years prior to the year of filing. And finally, that the petitioner's prospects for resumption of successful business operations are reasonable and not just based on the petitioner's assurances.
So, I mean, again, great example we have now is COVID, right? And like, so if you had a restaurant that was, let's say, doing $1 million a year every year, and then bam, 2020, that just craters to like 200,000. 2021, it bumps up to like 400,000, and then their priority date is suddenly in that space, right? In 2020 or 2021, and they're looking at those numbers and they're saying, well, wait a second, you know, you were paying him under the prevailing wage and you had a loss for the year, your net assets are negative. Like, no, right? Well, you can make this argument based off of this matter Sonegawa case and then the subsequent cases and guidance to say, well, no, here's the evidence that prior to 2020, right, we were making $1 million a year, right? This year was 2020, 2021 was not characteristic, and there's a reason for it, right? And then, of course, we have every reason to expect evidence, that once COVID goes away, things are going to reverse and we're going to have enough money. That's kind of the classic example here. But your facts need to fit that pattern, right? So if it's like, oh, well, we've since our company started, we've been posting a loss, but hey, we're really confident that we're about to, which is normal for a lot of startups, right? That you're going to run a loss for the first couple of years, maybe, and then all of a sudden you're going to take off. That doesn't work in this context, right? Because they basically said, no, 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 it has to fit this facts pattern. You have to show there were good years prior, then a bad year, and then you're going to have good years. So this one kind of people that kind of get hosed by this are like startups, right? Um, because they can't show prior really good years a lot of the times. Um, so, I mean, it does give hope to some people, right? But at the same time, you do have to fit that fact pattern. So, what are we're going to talk about some other um, things that they will consider in regards to ability to pay. And this comes from additional case law, really, that came out of matter of Sonegawa. So, what other factors may they consider?
So the number of years the petitioner has been doing business, the established historical growth of the petitioner's business, the overall number of employees, the occurrence of uncharacteristic business expenditures or losses, the petitioner's reputation within the industry, whether the beneficiary is replacing a former employee or an outsourced service, or any other evidence that USCIS deems relevant to the petitioner's ability to pay the proffered wage.
I mean, here's the key. These other considerations are purely discretionary, purely discretionary. So if you're in that camp of, hey, I'm not paying the guy enough, I don't have enough net income, and I don't have enough net assets, and then you're arguing these things, just be forewarned, it's discretionary. So you can argue them till you're blue in the face. I mean, you can say, hey, we have 500 employees and we have this great reputation. A lot of the times they'll ignore that stuff, right? Because it's discretionary. Now, they're more likely to consider it if you fit that fact pattern that we already discussed, right? That we had good years, uncharacteristic bad year, and then you can argue all of this other stuff as sort of as evidence as to why we think our fortunes are going to revert back to what they were. We're going to go back to good times, right? Because look at how many employees we had. Look at our historical growth. Look at our reputation. Um, they're more like factors to argue why we're expecting things to reverse course. But again, it's discretionary. I, you do not want this to be what you're banking your case on. Although there is one in here that I do like, and we've used a lot of time, and I think it's completely separate, and that is whether the beneficiary is replacing a former employee or an outsourced service. We've actually used this before, where the employer was getting something done by an external service provider that they were paying, and this guy's perm was specifically to come in and fill that position. So we were able to say, look at the $100,000 a year they're paying to this service provider. Well, once this guy gets his green card, that 100,000 is going to be redirected to his position because they no longer need that service provider. We've made that argument successfully before, sort of outside of the context of all the other stuff. That's a pretty solid argument, right? Or if you can show that they're maybe replacing another employee. Another one we've done before, and this is an interesting one, is what if the employer is ultimately a sole proprietorship? There's a single owner, essentially, of the petitioning company, of the employer.
So in that case, that person can actually use their own personal income to establish ability to pay. Essentially, you're talking about, yeah, my company's struggling. It doesn't have the funds, but I'm a millionaire. This is my one company, and I have the funds to pay the proper wage.
Yeah, we specifically had a case where there was a company that was fairly new. They had a ton of upfront costs and not a lot of income yet, so the numbers were bad. But the owner of the company was the CEO of a major US corporation. The type of people that make, let's say, between 20 to $30 million a year. And in that case, we actually got that CEO's personal income tax return and said, look, the owner is this individual. Here's his income tax return. Believe me, he has more than enough money. In this case, it was like a 10K difference, right? The guy's making $25 million a year. I think he can pay an extra 10K to this employee if need be. So again, when there's a sole owner, you can actually look past the company to the owner if that helps in terms of their net income, their net assets. And in that case, we were able to make a really strong argument. So again, the two main things when it comes to documenting an I-140 are the ability to pay, and then whether or not the employee meets 100% of the requirements in the PERM, right? Those are the two main things you're documenting. Personally, we're usually never not like documenting like a ton of, here's all this information about the company and what they do. Who cares? It's not relevant, right? What matters is like, hey, here's their tax return. Or a lot of things that are just kind of outside those specific requirements. For us, most of our I-140 packets, again, when it comes to EB2, EB3 cases following an approved labor certification, our I-140 applications tend not to be super big, right? Here's another interesting one we've run into lately, Andrew. Just throw this one out here. USCIS, since the pandemic started, has been accepted, reproduced signatures, right? Meaning someone could just sign, scan, and send it, and then we could send a copy of the scan, right? And we've been doing that now for 2 years. I-129s on the I-140 itself, every form, right? Really without issue, except for one. And what is the one that, for whatever reason, and again, this is not just us, we've seen other attorneys reporting the same. What is the one thing that USCIS, without much rhyme or reasons, just decided, no, this has to have a wet signature?
So the one that, and I don't know why, the certified ETA 9089, this PERM, has a place for the attorney to sign, the employee, and the representative of the employer. And for whatever reason, USCIS will still issue RFEs demanding that those be what we call wet signatures, which is an original signature versus every other signature page in the I-140 packet, the G28, the I-140 itself,
Right. The
support
employment
letters,
verification,
all
employment
copies.
verification letters, support letters, everything else in there can have a reproduced signature except the PERM. Because remember, when you file your I-140, you have to actually include the certified PERM, which that's usually like anywhere from 15 to 20 pages, and it has a spot that's signed by the Department of Labor, and of course that is a digital signature. That's fine. But yeah, it has to be signed by the employer, the employee, and the attorney. And for whatever reason, like I'm just going to tell you right now, if you're filing an I-140 with a PERM, make sure the PERM has wet signatures. Everything else is fine. It can be a reproduced signature. The I-140, the support letter, the employment verification letters, fine. Why on the 9089? I don't know. It's random. It's stupid. But again, that's not just us. I've gotten RFE'd on it. I've just seen reports from other attorneys. It seems to be a common thing. So if my I-140 is approved, does the I-140 technically have an expiration date?
Uh, Technically, no. There's none listed on it, and for a lot of people, especially our Indian nationals that get their approved I-140, you're gonna have to wait years before you can use it to apply for your green card.
Like, over a decade. Um,
10 years is what I mean by a few years.
um, although there is a context in which they kind of do have an expiration date. So if I file my I-140 and I select consular notification, remember we talked about those two boxes. Am I applying in the US or am I applying abroad? If you select consular notification, right, and your priority date becomes current, the National Visa Center will reach out to you and say, hey, here's some fees you have to pay and blah, 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 blah. Well, if you ignore that, or let's say you pay the fees, but then they say, okay, now go do your DS 260 and then you just don't go forward with it. After about a year, the NVC will close down your case. And then once they close down your case, they won't consider that I-140 anymore. This applies also to I-130s if you're doing a case through your family, right? USCIS will not consider um, sorry, the Department of State won't consider an I-140 if you had a case that went to the NVC and then you essentially didn't respond. So that's whoops, gonna move my camera around here. That is kind of the one context. Again, that doesn't apply to most of our people. And even if the NVC says basically we're no longer going to consider this, but then the person, I don't know, they get an H and then they enter the United States, they can still use that I-140 to adjust here, right? So again, there is no real expiration date on the I-140. Um, just beware of the NVC may ignore you if your priority becomes current and then you don't do anything with it. Um, does an I-140 by itself confer any immediate immigration benefits?
No, so I always feel like the best way to explain it is the I-140 is ultimately just the legs of your I-485 or your green card application. So the I-140 itself is approved. You can't remain in the country based off of it. You can't work based off of it. You definitely can't enter based off of it. You still have to go through the whole other process of either consular processing or adjustment of status.
So if you're not from India or China, it basically means you are eligible to file for residency if you didn't concurrently file, right? But it doesn't give you any status. So if you're here as an H and your H is about to expire, you're probably gonna have to file an extension and then also file the adjustment to residency. So really, what all it does is it says you're eligible to file for residency. If you're from India or China, really all it does is secure your place in line. Say, okay, you got a priority date now. Wait, there are some additional benefits, right? Because we know, like for Indian and Chinese nationals, having an approved I-140 allows them to extend their H beyond the 6-year cap. So there obviously are some benefits there, but it's not like an immediate thing given to you, right? You're actually going to have to separately file your I-129 to extend your H, include a copy of the I-140 approval. A lot of people just get confused. They're like, "Oh, the I-140 is end of the road, right?" Or I don't need to extend my H anymore once I get the I-140 approval. It's like, well, no, right? The I-140 just either secures your place in line or makes you eligible for residency. Um, can an employer after the fact revoke an I-140?
Uh, File a withdrawal, yeah.
Let's say I'm an Indian national, so I get an approved I-140, and I use that approved I-140 to file an extension beyond my 6-year cap. So I'm in my like 8th or 9th year, but I'm still 10 years out from getting my residency. I mean, it seems unfair to tell that person, well, no, you have to stay with the same employer for all of this period because if they revoke your I-140, right, you're toast, right? Is there a period at which an employee is protected?
I have never dealt with this, so I would actually have to look that one up.
This is what happens when I put questions in the text, but then don't put answers for Andrew. 6 months. Once the I-140 has been pending 6 months, um, it doesn't matter if the employer withdraws it. The employee can continue to use it to file H extensions, what we call AC-21 extensions, because AC-21 is the law that kind of created that exception. So once the I-140 has been approved for 6 months, the employee could hypothetically change employers, and then if the employer A gets mad and is like, "Well, I'm going to revoke your I-140," it doesn't matter. Now, the new employer is going to have to go through the whole PERM process themselves. In order to eventually sponsor this person, but they're going to be able to keep extending their H based on the original I-140 approval notice. So again, it has to be valid for at least 6 months for them to be protected. But then again, so what happens if I have an I-140 with employer A, I go to employer B, and let's say it's 5 years later and I get a new I-140 with employer B. Did I just reset my clock 5 years?
No. So there is a law that allows for priority date retention. So it's always important, if you have that prior approved I-140, you include it in the new petition, specifically request that they update the priority date, not based off of the PERM, but based off of the old I-140. Um, and a lot of times we'll see that they won't put that on there. So the next thing to do is, when you submit the I-485, you actually include both I-140s, one for the priority date and one for the actual position that you're applying for, or
Yeah.
that the employer's petitioning you
So,
for.
so in general, I-140s are not portable. It is portable in the context of H extensions, right? I can always use an approved I-140 from an old employer to file H extensions with a new employer, right? But it is not portable usually for residency. So the new employer has to do a new PERM, a new I-140. But the good thing is I get to keep the priorities. Again, if you're from if you're from India and you're gonna have a 12-year wait and you're already 5 years in, you don't want to reset those 12 years. That'd be terrible, right? You can say, well, no, I just got this I-140 approved, but we can use the priority date for my first one. So I'm not like resetting my place in line. Um, is it possible, let's say I file my I-140, I select EB3, and then I'm looking at the visa bulletin and EB2 has jumped way ahead, right? Or vice versa. I filed as EB2, now I'm seeing EB3's jumped way ahead. Is it possible to upgrade or downgrade an I-140?
Assuming that the position in the PERM qualified for EB2, yes, you can file upgrades and downgrades. And ultimately, once you have both of those I-140s, you would do a transfer request depending on what's current and get that filed with the I-485.
Yeah, but it does require you filing a whole new I-140 and paying the fee. Um, Now, we said that the underlying perm labor certification has a expiration date of 6 months, right? But if you already got an approved I-140, you can actually reuse an expired labor certification to file an upgrade or a downgrade. Um, so it is possible to say, "Oh yeah, I did this. We filed this I-140 3 years ago. The perm labor certification is way expired, but now EB3 is moving way faster. I want to file a downgrade." You can file a downgrade. You just have to file a brand new I-140, fill it all out just like you did the first time, right? Because it's based off the same perm labor. And the interesting thing is they used to not ever premium process. So when you got your perm labor certification approved, they would mail it to you on this blue paper, and that was the original, right? And you had to, if you wanted to file premium processing, you had to have the original. So you could never premium process a downgrade because you never had the original. The original went to the USCIS. The interesting thing now is they don't send you a paper copy. They send you a digital copy with a digital signature. So the question I don't actually know the answer to is, wait a second, if I'm filing a downgrade, can I just file premium processing? Because you're like, well, you can't premium process unless you have an original. Well, how is this not an original? I can just print it out, sign it again. Isn't it an original now? Again, I'm not sure I know the answer to that question, but it seems like logically you could not premium process an upgrade or a downgrade before. But now that the DOL is going to digital PERM labor certifications, how is it not an original as long as I print it out and sign it?
I would
Um,
have to look through case notes, but I am 95% sure that we filed premium processing with an expired original perm for either an upgrade or a downgrade. I'm
yeah,
pretty
we're
sure.
doing did a bunch of downgrades. Was it last year?
Yeah,
When
no,
EB3
when there
jumped
were a
ahead and everybody
bunch
was
of
downgrading.
jumps, and then there was a round recently where I did 2, 3 downgrades and transfer requests and such, so
Yeah, so I think you can file premium processing now. Because how is it not an original? I can just print it out and sign it. Because again, yeah, you used to get it in the mail and it was on blue paper, and that was the quote original. And if you lost that, oh my gosh, you were screwed. Trying to get a new one and all that. Although we did have a case once where they sent us the email, but like we didn't actually have it attached. We reached out to them and they did resend it. That was actually not too bad. We got it. So anyway, the main thing the main takeaway here is that again, once your perm labor certification is approved, you got to file your I-140. You have 6 months to do it. You're going to need to document ability to pay, and you're going to need to document that the employee meets 100% of the qualifications, right? Again, ability to pay, you have those 3 pieces of primary or 4 pieces of primary evidence that have to be there. Um, and then, yeah, once your I-140 is approved, then hey, you're either eligible to file for residency or you can currently file for residency. Or if you're from India and China, hey, you're in a waiting period, but luckily you'll be able to file H extensions based on that approved I-140. And your spouse will be able to apply for work authorization, right? Because H4s, spouses of H1Bs, are not work authorized. But the Obama administration created an exception where if you have an approved I-140, then the spouse. So approved I-140 benefits the principal because now you can file H extensions, and it benefits the dependent because they can now apply for work authorization. So there are some benefits to getting this done. Anyway, Andrew, this concludes our series on the PERM labor certification process, kind of from start to beginning. So again, if you're interested, go back. We have a video on getting a prevailing wage determination from the Department of Labor, a video on recruitment, a video on filing the actual PERM 9089, and then of course this video on the I-140. So we walk you through the whole process. We also have videos on all the non-immigrant visas. We have visas on all the other employment-based residency categories. So if there's something you're interested in, think you may qualify for, go back, look through our video history. There's something there for you. We also do a lot of immigration updates when there's anything happening in the news. Also, remember, any questions, you want to talk to us, you want a consultation, go to our website. You can schedule a consultation directly through our website. You can also call. And always remember, we have an app called Lawpilot GUARDIAN for Android or iOS. Go download the app. Lots of useful information there. And we're always adding new features. But until then, Andrew, thank you as always for being along for this ride. And hey, stay tuned for our next videos. And by the way, feel free to leave a comment if there's a video, if we have not done a video that addresses something that you think we should do, because we're always looking for new things and new points to address. So feel free to ask any questions or leave a comment on something you want us to do. But until then, thank you for tuning in, and we'll see you next time.